one of the things we did not discuss that is new is that they changed the age laws for criminal cases. And so family court also has jurisdiction over criminal cases involving minors. Ages 18, 17, 16, 14, 15. All of that gets adjudicated in family court, which means these judges actually preside over legitimate trials that do have a burden of proof beyond a reasonable doubt.
Dude, is there a level of severity that takes a juvenile case out of family court, even if a juvenile is charged with homicide or something like that? Would it stay in there, or I mean, I guess every jurisdiction it depends on the DA's wanting to try somebody as an adult or a juvenile or
violent crimes like homicide, using a weapon like an assault 1 charge. Rape,
assault 2,
rape, like completed rape 1, even maybe a rape 2. Those kinds of things are qualified offenses that can be done in criminal court.
Okay. Yeah, and that's subject to who? The DA, the judge? Is there a hearing to determine that?
Homicide is absolutely not going to be in the family court. Rape 1, absolutely not in the family court. Assault 1, not in the family court. But if you say
attempted homicide of shooting where you have it on camera but there's nobody hit,
also not in the family court, right? Because if it's an attempted murder, right? But what you might have is somebody has a rob 3, right? It's a D felony. It's not necessarily a qualified offense. You have to submit a written application to the judge who handles the juvenile part in the Supreme Court, and they have to essentially show why the case should be held.
Yeah, there's like a whole. So at my public defense firm, we have an adolescent
juvenile rights.
No, not juvenile rights. Because juvenile rights, I feel like
that's something
separate. They have they made an adolescent part, and what they do is they represent these clients, and they basically a big part of their practice is try to get the case removed to family court. So what happens at arraignments is the DA on a qualifying offense either choose to remove to family court or chooses not to. If they choose not to remove to family court and bail gets set, basically gets put on for the next day in the adolescence part for the judge to determine if they want to keep them on bail or not. And then there's because I stood up on one of these cases. So I know, we're going to do an episode on the adolescent part in the future. But there's a 5-day review to determine if the case should stay in criminal court or Supreme Court, like that a judge has to do within 5 days, and there's like a whole motion they file.
No, the written motion they have 30 days to file the motion and get it done. If they don't do it within 30 days, then it gets remanded back to family court by the judge's decision.
So there might be multiple stages to this, but I know there's definitely a 5-day review in which they not necessarily a motions ran, but they review whether they want to, and like there's a whole standard. I believe so I'm butchering it, but there's if depending on the nature of the crime, it might be automatically removable, and then it gets argued that, hey, because of this reason, we've looked into it, it has to get removed. And that happens at 5 days, and I think it happens again at 30 days.
Yeah, you're thinking of the standard for violent offenses. They have to show within 5 days at a hearing, which is called a retention hearing, that they're going to keep the violent felony in the criminal court supreme term for juveniles, not let it go to family court.
Exactly.
But the ones that are non-qualifying offenses or not mandatory qualified offenses, those are the ones where we have 30 days to submit in writing your reason for keeping the case in the Supreme Court.
Okay.